Your estate plan does not control all your assets. Most people believe their trust or will decides who gets everything when they die. That is incorrect. Several major assets transfer by federal law and contract, not by your estate documents. Here is what actually controls. If you have a 401k, pension, or many employer-sponsored retirement plans, they are governed by the Employee Retirement Income Security Act, ERISA. Under ERISA, your spouse is automatically the primary beneficiary. You cannot name your children instead unless your spouse signs a written, notarized waiver. The waiver must comply with ERISA requirements and be accepted by the plan administrator. Your trust does not override this. Your will does not override this. A prenuptial agreement usually does not override ERISA. Why? Because ERISA requires the waiver be signed after marriage. The person must actually be your spouse at the time of consent. The consent be in writing. The consent acknowledge the specific alternate beneficiary designation. The signature be notarized or witnessed by a plan representative. A general statement in a prenup like, each party waives rights to retirement accounts, often fails to meet these federal requirements. If the ERISA waiver is missing or defective, the plan administrator must pay the surviving spouse, even if your prenup, will, or trust says something different. Federal law controls it. Life insurance, IRAs, and many financial accounts transfer by beneficiary designation. That means the form on file with the institution controls, not your trust, not your will. If your beneficiary form says spouse, that is where the money goes, even if your trust says otherwise. Estate planning requires alignment between documents and beneficiary forms. In community property states such as California, Texas, Arizona, Nevada, Washington, Idaho, Louisiana, New Mexico, Wisconsin, a spouse may legally own 50% of assets earned during marriage, including retirement contributions. You may not be able to redirect that portion without spousal consent. State law controls it. Estate planning is not just document drafting. It is coordination across federal law, ERISA, state property law, contract beneficiary designations, trust distribution terms. If those pieces are not aligned, your plan can fail, even if your trust is perfectly written. The most common estate planning mistake is assuming the trust or will controls everything. It does not. Before assuming you control your retirement accounts or that your children are protected, review your 401k beneficiary form, whether a valid ERISA-compliant spousal waiver exists, your IRA beneficiary designations, your life insurance beneficiaries, whether you live in a community property state. Control in estate planning comes from alignment, not assumptions. Wolf Trusts and Estate Planning, protecting your legacy. wolftrusts.com